who have joined us for this special session on the topic Art of Conducting Court Proceedings and Art of Writing Judgments. On behalf of Maharashtra Judicial Academy, I would first extend a warm welcome to Honorable Shri Justice A.S. Oak, Judge Supreme Court of India. Lordship has accepted to conduct this session despite a very hectic schedule today. We are also blessed with the presence of our officiating director of MJA, Honorable Shri Justice R.D. Dhanuka, Honorable Shri Justice G.S. Kulkarni, Honorable Shri Justice V.G. Bisht, and Honorable Shri Justice Madhav Jandar, who are attending this session with us. We have two induction batches who are participating in this session, one of 88 judicial magistrates first class and the other of 6 district judges who have taken oath on 22nd of January. Of course, there is no need for any introduction of Honorable Justice Oak Saheb, but today we have a very special introduction by Honorable Shri Justice G.S. Kulkarni. Lordship will be giving a brief introduction of Honorable Oak Saheb. So without taking further time, I request Honorable Shri Justice G.S. Kulkarni to give introduction of Justice Oak.
Good evening and greetings to all. It's my proud privilege to introduce our Justice Abhay Oak, one of the most distinguished judges of the Supreme Court of India, today evening on the occasion of his Lordship's lecture on the topic Art of Conducting Court Proceedings and Art of Writing Judgment. Very important topics for all of us as judges. As rightly pointed out by Mr. Agrawal, his Lordship requires no formal introduction. With his Lordship's intricate and the deepest connect, which he has with all of us and our fraternity in Maharashtra, this would add to, as what Mr. Agrawal said, no formal introduction is necessary at all. His Lordship's journey in law started in 1983. His Lordship practiced at the bar for 20 years from 1983 to 2003. He practiced at the district court and thereafter in the High Court. He was elevated as a judge of the Bombay High Court on 29th of August 2003. And for 16 years, he was the judge of our High Court. On 10th of May 2019, his Lordship was elevated as the Chief Justice of the Karnataka High Court. On 31 August 2021, his Lordship was elevated as a judge of the Supreme Court of India after being the Chief Justice of the Karnataka High Court for 2 years and 3 months. I would like to introduce Justice Oak in a little different manner, and I would categorize such introduction in 3 stages. Justice Oak, as I have seen his Lordship as a lawyer at the bar. Justice Oak, as I have seen as a judge when I appeared and I got the opportunity to appear before his Lordship. And Justice Oak, as a senior colleague judge on the bench, when I had the opportunity to share a bench on number of occasions with his Lordship. Now coming to the first stage of his Lordship at the bar, when as an advocate, I had the privilege, I should say, to see his Lordship at the bar from the year 1992 to 2003, which is almost 11 years. His Lordship was the busiest lawyer on the appellate side, always well prepared, very balanced in his submissions. Always his Lordship found first his duty as a lawyer towards the court, as an officer of the court. Fairness to the other side was always seen in all his appearances. I would narrate one of the experiences where his Lordship was my opponent in a second appeal, which was before Justice Khandeparkar. I was of the opinion that I had a good case And so also Justice spoke when at the bar, when we discussed the matter before the matter was called out, he said, very difficult for my client. And the arguments took place, and the court was quite impressed with Lordship's submissions. And the court found that the second appeal needs to be admitted as also an interim relief ought to be granted. And we came out of the court. And after coming out of the court, see His Lordship fairness. He said, Girish, this is nothing but luck of the client. My client had no case whatsoever. That was His Lordship fairness to the other side, which is very creditable and very rarely seen in our profession nowadays. He enjoyed great respect from the court and lawyers at the bar. This was Justice Abhay.S at the bar, as I know him. Now, appearing before His Lordship as a judge, His Lordship had the most outstanding qualities of fairness to all the lawyers who appeared before him. Senior or junior made no difference. The lawyer would always be required to be prepared from cover to cover, including the pleadings which are filed by the other side, because you never know what question would fall from His Lordship and when you would be stumped behind the wickets. The feeling every lawyer had after he argued his matter before Justice Oak was of full satisfaction. Whatever may be the consequence of the order which would be passed, but he would walk out of the court with full satisfaction that his client was fully heard and a order befitting the matter was passed. This was Justice Oak as a judge. His Lordship had rendered landmark judgments on many issues not only in Bombay, but also in Karnataka. And every day these judgments are cited and guide us in our judicial journeys. As a senior colleague at the bench, I had the occasion to be with His Lordship on the computer committee as also on the arrears committee for some time. The work, I got to learn so many things. He was always prepared with the paper books, with the latest on the issues, subjects, and which was a very important experience for us, and particularly me when I was a junior judge, to pick up so many things on these intricate issues. Justice Oak was always a very hard-working judge. He devoted almost from morning 10 o'clock up to 8:30 in the evening in the court. He was absolutely dedicated and devoted to the institution. The cause before him, a long list of path-breaking judgments, is the testimony of His Lordship's contribution on variety of subjects as seen from his judgments. The most important thing, and which I feel is absolutely creditable and very difficult for any one of us to catch up, is that His Lordship would be prepared even in the 100th case on the cause list. I don't know how he managed this, but he used to know what is the point, page number, and what is the issue in the matter. Even if somebody mentions the matter out of turn, he would be ready with the answer that no, this time we are not going to adjourn, see page number so and so. This is the issue, it is already possibly concluded. Now, as far as His Lordship's contribution, we have seen His Lordship's judgments from Karnataka on variety of subjects. They keep guiding us. Some judgments which are recently delivered by His Lordship in the Supreme Court are definitely of importance, and they are the law of the land under Article 142, which would certainly be of immense help to the litigants and the society and the fraternity of lawyers and judges. I would not stand in the way of His Lordship now speaking and addressing all of us on the important issues. We are very eager to hear His Lordship. With these few words, I end my small introduction. and request your Lordship to continue. Thank you.
My esteemed colleagues in the Bombay High Court, Brother Justice Ramesh Dhanuka, Brother Girish Kulkarni, Brother Justice Bisht, Brother Justice Madhav Zamdar. I am really grateful to Brother Justice Girish Kulkarni for his introduction. I have very happy memories of sitting with Justice Girish Kulkarni on bench for quite a long time. I had occasion to hear very lengthy matters and bulky matters while sitting with him. Justice Dhanuka, of course, I know him intimately as a lawyer and as a judge. Justice Bisht, though he became judge of the Bombay High Court after I left the court, I know him for years. He was associated with judiciary in different capacities. Justice Madhav Zamdar, initially I knew as junior of very eminent lawyer, Mr. M.A. Rane, and thereafter I have practically seen his entire career as a lawyer. He must have appeared before me in several cases. Mr. Agarwal, Joint Director, other office bearers of the Judicial Academy. Normally, I prefer to come to the academy and interact with the judges. But this time it was not possible. Firstly, I welcome the newly appointed district judges to the judiciary. As far as civil judges are concerned, I think I had occasion to address them very recently. Therefore, for the civil judges who were present in my last lecture, few points will be repetition. Of course, the topic on which I addressed them was different, but there is some overlap. To begin with, I want to tell you something with great emphasis. I always believe that our trial courts, courts of civil judges, courts of magistrates, courts of district and session judges, they play the most important role in our judicial system. To take recourse to Marathi, I always used to say, पक्षकाराचं भवितव्य ट्रायल कोर्टामध्ये घडत किंवा बिघडत असतं. According to me, the most crucial role is played in our judicial system, hierarchy of judicial systems up to Supreme Court by our trial judges. For the benefit of young judges, I want to tell something which I did in Karnataka. One of the first administrative orders which I passed was a direction to our district judges and senior civil judges in Karnataka, because there even senior civil judges exercise appellate powers. The direction was not to refer to any court as lower court or subordinate court, because I believe that in our judiciary, no court is inferior, no court is subordinate, no court is lower. Only different roles are played by courts at various levels in our hierarchy. So I want to start with emphasizing one fact, that all of you are going to play a very important role in justice delivery system. The topic, the first part of the topic is art of justice. When we talk about art, it is always said about a singer, about an actor, or an artist who draws paintings, that art has to be inborn. It is to be inborn. We say it about those who are there in sports also. Of course, in these fields, the art has to be inborn, but it needs a lot of hard work and efforts. But judiciary is one field where there is no question of inborn art. Art of judgeship is something which you can develop yourself by self-education, by following others who are role models as judges, by sheer experience, and most importantly, by hard work and dedication. It's not easy to sit in the open court, hear the parties, and to decide a case. It needs a lot of hard work. It needs a lot of self-introspection and learning. Now, what is the key to the success as a judge? How you can develop the art of judgeship? Now, the first and foremost requirement is very sound knowledge of law and very sound knowledge of procedural law. That's something which is essential. The second thing is a very strong common sense and right approach. One more quality we require, which can be developed with practice, is humility and humbleness. Another key to the success is that you must realize that court time is very precious. We work for 4.5 hours, 5 hours, or 5.5 hours every day. So every minute, every second of our court time is very precious. Other requirement is that there has to be a clarity of thoughts. You must know what you are doing. You must know what you are supposed to do. All this has to be considered on the background of huge areas which our system is facing. In the state of Maharashtra, always there has been huge filing both on the civil and criminal side. There are various reasons why this happens. One of the reasons can be that our state is one of the progressive states. As a result of the progress which we have made, more and more litigation is created. Pandemic of COVID-19, first, second, and third wave had impact on functioning of the trial courts. The reason is that High Court could function with VC, but our trial courts found it difficult to record evidence of witnesses by use of VC. Those who are studying National Judicial Data Grid will immediately realize what I am saying. The pendency has multiplied during last 2 years due to reasons beyond our control. It is going to be a huge task before the judicial officers or judges for that matter, those who are working even in the High Court, to get rid of arrears. I am not on statistics today, but if you are a student of statistics, you can prove that due to this pandemic, we have gone back by 5 to 6 years or even more. So this is going to be the huge challenge before us to deal with arrears. Now, basically, when I started with key to the success, the last thing which I want to tell you about the key to the success is reading your files when the case is for effective hearing. reading your files so that you become conversant. The files are not to be read so that you are predetermined about the decision which you want to render. I'll come to that very shortly, why it is relevant and why it is important to read files. Now coming to the judgeship or the role which you have to play as a judge. I began by saying that you are going to play a very important role in our judicial system. One of the most important duty assigned to the trial judges is to record evidence. The evidence has to be recorded with perfection, because if there is a mistake in recording evidence, that remains in perpetuity, that may harm the cause of justice in perpetuity. Because what you record during the course of trial cannot be corrected by any court which is as per hierarchy higher than the court of trial judges. As you grow old as judge, you will realize you have to be very meticulous in criminal matters while recording the omissions and contradictions. Which portion of statement recorded under section 161 is to be marked? That is very crucial. Of course, there are catty now judgments starting with Tahsildar Singh on this subject. I'm just on broad points which constitute part of art of judgeship. One of the most important quality which you'll have to develop is studying the lawyers. You will be posted at a particular station normally for a period of 3 years. Therefore, it is important to study the lawyers who appear before you, but they are going to appear before you for a period of 3 years. The reason is you must know which lawyer is fair, which lawyer is best prepared. There may be category of lawyers who always believe in taking adjournments. Those we call as adjournment masters. There are lawyers who are very intelligent, well prepared, but they are not fair to the court. There are lawyers who are very aggressive in the court, who can try to browbeat the judges. Some of you must have practiced law for quite some time, especially those who are appointed as district judges by nomination. I was a lawyer practicing for 19 years. I always used to tell my junior colleagues, whenever a new judge was appointed in the High Court, that will not argue many matters before the new judge, will sit in his court and observe how is the judge, how is his approach, how he reacts. In the same manner, ultimately as a lawyer, art of advocacy is important. Therefore, when I appear before a court as a lawyer, I appear before a judge as a lawyer, I must know how is the judge, what is his approach, how he deals with peculiar situations which arise before the court. In the same way, you must study the lawyers. You must identify the category of lawyers who can be told to argue in detail on a law which you do not know. I have seen this happening for 2 or 3 years. I have practiced in the district court. I have seen this happening. Many good judges used to tell the lawyers, after knowing that lawyer will really assist the court, they used to tell the lawyer, by frankly telling the lawyer. I remember a very good judge who ultimately retired as judge of this court, telling a lawyer that he had never dealt with references under section 18 of the Land Acquisition Act 1894. And therefore he requested a very distinguished lawyer to argue in detail to show all the relevant case laws on determination of market value and various tests which are laid down, comparison method, etc. Because you ultimately need assistance from the lawyer. Without assistance from the lawyer, you cannot succeed as a judge. So therefore, studying the lawyers is very important. One more important study is required to be made by the judges. The studies of your own file. What are the cases assigned to you? What are the stages at which the cases are pending? Whether dates have been assigned to each and every case or whether some matters are undated. What are the stages of the cases? What are the category of cases? Because ultimately, as a judge, you must know how priority is to be given to certain cases. You must know how many matrimonial disputes are pending in your court. How many are the cases of very old senior citizens? How many are cases relating to custody of minor child? How many are commercial suits? I'm just giving you few illustrations. Therefore, I always advise the judges to maintain a diary. In that diary, whenever cases are called out, you must note. For example, if you frame issues in a particular case and list of witnesses is filed, you must enter in your diary the date fixed for recording of evidence. You must also ask the lawyers how many witnesses they want to examine. You must have very tight control over your file. Only if you maintain your diary and make entries of cases on a particular date. I'll give you one more example. If you have come across partition suits or suits for administration of estate, by its very nature, the suits remain pending. Parties die, their heirs are brought on record, heirs are not served. So if there is a very old case which is still pending for service of summons, such cases need to be given priority. What is important is you must also pay attention to execution proceedings. Execution proceedings are of vital importance. A litigant files a suit with the object of getting fruits of his decree. If he is not going to get fruits of the decree because execution proceedings remain pending for a long time, the entire system, legal system will be defeated. So you must take a note of how many execution applications, old execution applications are pending. Only if you know your file, you can decide the question of giving priorities. Only if you know your files, you will be able to adopt case management techniques. Only if you are maintaining your diary, you will know that you are not keeping too many cases for recording of evidence on a one particular day. Many judicial officers ask me a question. Sir, while we discharge our duties, we have to give minimum disposal. In some proceedings, you get only 0.5 units. In some proceedings, you get 1. In some proceedings, you get 2. In some proceedings, you get 3. And if you concentrate on old suits or old criminal cases which are bound to take time, you are not able to meet the target fixed by the High Court, the minimum quota given by the High Court. I understand this point of view. And therefore, case management is required. You must give priority to old suits, whether they are heavy or otherwise. You must give priority to old criminal cases, though they are likely to take time. At the same time, you can give priority to few cases which can be disposed of without any effort so that you can achieve your target. Now, this is possible only if you thoroughly know which are the cases and what are the categories of cases pending before you. I am talking about maintaining a physical diary because I belong to old generation. Actually, what you can, I think almost all of you must have been on laptops. You can have soft files, a soft diary can be created. You can keep on updating it. So study of your file is important. I'm not giving you warning, but after advent of National Judicial Data Grid, there are many institutions which are analyzing the data which is available on National Judicial Data Grid. As the Chief Justice of Karnataka High Court, I used to get reports from many such institutions, many trusts. I'll not name them, you know them, where they analyze how the cases are being disposed of. In the report, they write that a particular judge has granted 15 adjournments at the stage of final arguments in a criminal case, because now everything is on public domain. Recently, you must have learned about it. Now, the government of India wants us to display what is known as justice clock. The justice clock will have display of figures on the National Judicial Data Grid. So gone are those days when public at large does not know how the judges are functioning. If you see National Judicial Data Grid, you will know how many cases are undated, unattended cases. So therefore, now what you do is under public scrutiny. I am not saying that you should be afraid of public scrutiny. If you are a good officer, if you are a dedicated officer, you need not bother about what social media says about you, what the public says about you. My point is different. My point is now common man has started assessing our performance based on statistical data. Of course, that statistics can be misleading. A judge can be dealing with a case which has say 200 or 300 witnesses. So the record will show that the judge has not disposed of any case for any main case for 2 months or 3 months because he is recording evidence in that. So statistics can be misleading. What I am trying to tell you is that statistics can be used, statistics available on National Judicial Data Grid can be used to your advantage. And please ensure that there is no data mismatch. The record, that is Roznama, which you maintain has to be consistent with what is there on CIS, what is there on National Judicial Data Grid. So to conclude, please study your file very carefully. Apart from the priorities which are already laid down, that senior citizens cases are to be given priority, please set your own priorities. Some of you may deal with matrimonial cases. Some of you may, especially the district judges, you may be posted in family courts. In family courts also you require right priorities to be set in. I'll just give you one example. If there is a divorce petition where the parties are more than 50 or 60 years old, and we have other divorce petitions where young married couples are fighting, they are in 20s or 30s, naturally you must give priority not to the cases of those who are old, but to the young couples. They have to lead their own life. So adjusting the right priorities is now today's requirement, because we have been often criticized that you don't have priorities. You decide cases which are very easy to be decided. Therefore, have proper priorities set in, and that will happen only after you have complete control over your file. Now coming to the other topic which I referred some time back, reading the files. Ultimately, as a judge, you have to develop your own mind. We in High Court, we read the files beforehand. But we develop our mind in such a way that we don't decide the matter finally. We read the files only with a view to ensure that we must know the factual aspects. We must know what is the controversy involved so that nobody can mislead us. Normally, when I come to Judicial Academy, I request you to read very interesting autobiographies by various eminent judges, starting from Justice M.C. Chagla, Roses in December. If you read that autobiography, some of you must have read by this time, because these are my own Boswell by Hidayatullah. So many such autobiographies there. They are really like a Bible or Bhagavad Gita or whatever holy document you call for the judges and lawyers. Justice Chagla in his book has said that it is not a good policy to read the case files before you hear the matter. You must remember that Justice Chagla was judged prior to independence and about 12 years after the independence, till 1958 or 59. Those were the days when our courts were not crowded. There used to be very few cases. Now the time has changed. Now all the courts are flooded with cases. And with the changing time, it has become absolutely necessary that you read the files. I'll give you a few examples. If you are dealing with a civil suit, when the case is fixed for framing of issues, it is advisable to read the plaintiff and written statement if you are going to frame the issues in open court. Because only if you have read the plaintiff and written statement without loss of any major time in the court, you will be able to formulate the issues. If you draft the issues after reading the pleadings, that avoids all the further applications by the lawyers for recasting of issues. Taking further example of a civil suit. Now, after amendment of 2002 to CPC, amendment 2000 rather, now all the examination chiefs are in the form of affidavits. So you have to formally record the evidence by taking the affidavit on record, mark the documents as exhibits, and then start with cross-examination. Unless you know what is the case pleaded in the pleadings, how you are going to decide whether a question which is put in the cross-examination is relevant or irrelevant. Only if you have the pleadings, you have grip over the facts, then you will be able to tell the lawyer that the question which he is asking is irrelevant. Take a case of final arguments. You know, there are lawyers and lawyers of different category of lawyers. Now there are some lawyers at the time of final hearing, they start reading the pleadings right from the title, in the court of civil judge so and so. That is the way they practice. But I always believe that at least 50% lawyers in any station, any place, they are reasonable. If you have read the matter, read the case papers, you are able to curtail the arguments. You can always suggest to the lawyer in very, very politely that, look, I know what is the case of the plaintiff, I know what is the case of the defendant, what are the pleadings, what is the evidence. So please come to the point. There is one more reason why you should be conversant with the pleadings when you hear the matter finally, or when you are hearing even interlocutory applications. The reason is that if you have some doubt, you can ask pinpointed question to the lawyer while the arguments are being heard. If you ask the doubts, it is always better for the lawyer, because only if you ask the doubts to the lawyer, it brings best out of the lawyer. Ultimately, that helps the cause of justice. If you are going to record evidence in a case where evidence is recorded by your predecessor, it is always necessary to at least cursorily go through the evidence, the notes of evidence. That is absolutely necessary. Criminal cases, of course, you have to read evidence before you record statement under section 313. In many cases, I have found that provision of section 313 is taken very casually. Unless you know what is the evidence against that particular accused, the evidence which has come in the form of depositions of prosecution witnesses, evidence which is in the form of documents, you won't be able to properly formulate questions under 313. There are cases and cases which result into acquittal because one particular material, one particular evidence which is adduced against the accused is not put to him in 313 statements. So therefore, in that sense also, it is absolutely necessary to be conversant with the notes of evidence which have been recorded. There is one more part of reading by the judges. You have to be very up to date with the case law. And now it's very easy for you. I believe that almost all judicial officers have been given laptops. They have SCC online, or maybe Manupatra, maybe any other thing. Now, it is very, very easy to make research, easy to find out what are the judgments delivered by your parent High Court or Supreme Court on a particular topic. You have to be updated. I'll tell you the reason why. Of course, to the credit of some of the younger judicial officers, I must say that they are updated. I remember as a guardian judge of Pune district, I was holding a workshop. I don't remember what was the topic. Maybe it may be Information Technology Act or something, I don't recollect. So in open session, I referred to a judgment of Bombay High Court by telling the judicial officers that that is a judgment which will bind them. One young judicial officer got up and he told me, sir, pardon me, but 3 to 4 days back, Supreme Court has delivered a judgment and the judgment of the Bombay High Court, which you are referring, has been set aside and exactly different view has been taken. I had same experience while interacting with some of the judges in districts in Karnataka. That is what we expect from the young judicial officers. It's very easy now to remain updated. It is very important for you to remain updated with the case law for two reasons. The first and foremost reason, of course, that will help you to correctly decide the cases. That will help you to decide the cases as per the law which is laid down. The other advantage of that is that in many cases you are able to curtail the arguments by the lawyers. Today, unfortunately, as these tools are available to judges, you can have immediate access to all the latest judgments. By one click of button, you get 100 judgments on a particular point. So sadly, today we have a scenario where not only in High Court, but in all courts, where on one topic, one judgment is sufficient, lawyers would come with 10 judgments. If there is a direct judgment of the Bombay High Court, if there are more than one direct judgments of Bombay High Court, they will bring copies of all. They will also get judgments of other high courts taking the same view. If there is a direct judgment of the Supreme Court on a point, they will also get judgments of several high courts taking the same view. So now the practice is, to throw the large number of citations at the judge. To deal with this menace, you should be very, very equipped. Again, all lawyers are not reasonable. There are many reasonable lawyers. If you are thorough and you are very well prepared, when you are hearing final arguments, you can always correct the lawyer. You can tell why you are citing the judgments of High Court. There is such and such case where Supreme Court has decided the issue. It is also important that the lawyers know that you are conversant with case law. For that purpose, I was all along following as a judge a different technique which I followed even in Karnataka. Depending upon the nature of assignment, I used to keep files containing copies of the latest judgments of the High Court and Supreme Court on the dais. I followed that in Karnataka also. I used to change the files after my assignment used to change. It had two advantages. One advantage, the first and most important advantage was that the latest judgments were accessible easily to me because it's very difficult to remember the citations. You only know sometimes you feel that there is a direct judgment, but you can't get hold of it immediately. So that is ready. And the second and equally important is that gives notice to the members of the bar that the judge is equipped with the judgments. He knows the latest case law on the point. That's very important. Ultimately, you must give right signals to the members of the bar if you want to succeed as a judge. Of course, you need not keep the files now. All of you are techno savvy. You can have your own files on your laptop or your desktop, whatever is there. But you can keep that, because if you are working as a judicial magistrate first class, you'll be getting many cases under DV Act or 125 CRPC. Keep the latest case law ready with you. That will help you and that will give right signals to the members of the bar. In this connection, there is one more aspect which I must tell you. Some minutes back, I referred to the fact that the court time is very precious. You can't waste a single minute of the court. Therefore, you have to make a lot of thinking about how you are discharging your duties as a judge. I have practiced as a lawyer before the civil courts also. Sometimes I used to get impression that judges are spending a lot of unnecessary time on few things. Like few days delay in application for bringing on record the legal representatives. Simple applications for issuing fresh notice, simple applications for substituted service. In criminal cases, simple application under section 311 of CRPC. In such matters, you got to adopt a very liberal approach so that it can save a lot of time in the court. As I said, you require robust common sense. I am giving one example out of context. If you have read the book by Justice MC Chagla, who was just in December, he has referred to one case decided by him. He was when he was Chief Justice. Those were the days I am talking about 40s and 50s, when there was a lot of craze about the imported articles manufactured abroad. So one merchant had gone to some European country. While coming back to India, he brought with him gold top fountain pens. It was a normal fountain pen, but the top of the fountain pen was made up of gold. So custom duty was charged. Custom duty was different on articles of stationery, and custom duty was different, much higher custom duty for articles made up of gold. The customs authority took a view that this is article made up of gold. It is not a fountain pen. So ultimately, matter was carried to the High Court. Advocate General appeared for the revenue. After the matter was called out, Justice Chagla asked only one question to the Advocate General. He said, Advocate General, can you give me one article out of several which were brought? So Advocate General handed over that gold top fountain pen to the Chief Justice Chagla. While holding the fountain pen in his hand, he asked the question, Mr. Advocate General, can you tell me what is the article which I am holding in my hand? In split second, Advocate General answered, Sir, you are holding a fountain pen. So Justice Chagla asked him, is that not the end of the matter? Of course, I am oversimplifying it, or maybe Justice Chagla may have oversimplified it. So what you require in dealing with some small issues is a very robust common sense. You must use your common sense. Now, before I go to the art of writing judgment, there are several other aspects which are part of this art of judgeship. When you start sitting in the court, you realize one more important thing, that you are going to deal with different categories of human beings. The lawyers, all lawyers are different. Their approach is different. Their behavior is different. You will deal with many litigants. Their behavior will be different. Ultimately, litigants are the main stakeholders. If you deal with the litigants who are involved in matrimonial dispute, you will find that they are very much affected because of the ongoing dispute. So you are going to deal with human beings and human issues. It is therefore absolutely necessary that you must know what is happening in the society. I always tell young judges that you should involve yourself in reading, general reading, apart from the law. If there is a good movie, if there is a good drama, you must see that. Because you must know what is happening in the society, how the society is evolving itself, what are the trends in the society. If you are fond of a music, please go and attend very good musical concerts without compromising on your duties as a judge. The reason is that you must know what is happening in the society. You must know how the human beings behave. About the behavior of the advocates, I have told the young civil judges. There was one very prominent lawyer in Pune who has written a book. I had read it personally when I was a law student. That book was written in 50s. I tried my level best. I am not able to get copy of that book. The title of that book was Punyache 420 Vakil. This 420 has nothing to do with section 420 of IPC. When he wrote the book, there were 420 members of the Pune Bar Association. So he has categorized those members into different categories. One category he has said lawyer number 1 to 20. This is a category of lawyers who, with some excuse, try to enter the chamber of the judge and to have chit-chatting with the judge. Category number 4, say 300 to 320. The lawyers who are adjournment masters. One category of lawyers will be always aggressive with the judges. One category of lawyers who always believe in praising the judges. So different categories. And I remember correctly, it was such a beautifully, categorization was so beautiful that you go to whichever court, you will find lawyers falling in the same categories but with different names and with different faces. So these are the category of lawyers whom you are going to deal. Only few tips which I want to give to you. Which of course there will be repetition for the civil judges. But I want to say this with emphasis because there are 6 district judges, newly appointed district judges. The times have changed now. Minimize occasions for lawyers entry into your chamber. Very limited cases, some lawyer wants to invite you for marriage of daughter or son, or maybe some lecture in law college, you allow entry. Of course, when you are posted at a particular place, it's not a good strategy to be very blunt with the lawyers and tell them, don't enter my chamber. Strategically, you must make your views known to the lawyers that you are not welcome in the chamber. I always give illustration. In many districts in the state, it's a good practice which is being followed. If a case is fixed for recording of evidence or case is fixed for final arguments, on the earlier day, the lawyers enter the chamber of the judge and tell the judge that he has some personal difficulty, he won't be able to attend next day because he wants to ensure that judge should not read. It was a very good and healthy practice. But now question is whether you should follow that practice. So whenever lawyer representing one side enters your chamber just to tell you that he's going to seek adjournment tomorrow, please tell him very mildly and politely that look, next time if you want to make such a request, please ensure that the lawyer who is opposing you also comes with you. Or you can even tell him that you can mention in open court your difficulty about the next day. Never ever hear a matter in chamber. Of course, there are recognized exceptions like matrimonial matter, where it is your duty to intervene and convince the parties to settle a dispute, family dispute. There is an obligation in CPC also. These are different matters because there the litigants are in the chamber, the lawyers are in the chamber, or in camera proceedings. Even in camera proceedings, I have a suggestion to make, which I have made not only while addressing Maharashtra Judicial Academy, but other judicial academies as well. If you are going to hear a matrimonial dispute, maybe 125 or Domestic Violence Act, where you are going to record evidence, lawyers make a request, sir, record it in camera. One way, what is ultimately in camera? In camera is those who are concerned should be there, nobody else should be there. So other thing you can do is possibly allow entry of the lawyers appearing in that case or their juniors, the parties and your court staff, and close the doors of the court. So instead of doing the exercise in your chamber, you can record evidence in open court. That will be also in camera because nobody else is allowed. There is no open court hearing. In many cases, I have seen personally as a lawyer appearing in the district court that judges are sitting in chamber in the evening, some urgent suit is moved for ex parte injunction. Judges used to take it in chamber. Don't do that. You occupy your seat in the open court and then hear the matter. Because you know the basic principle which is told to all of us that justice should not only be done, it should be manifestly seen to be done. As I said, the times are changing. In 60s and 70s, nobody used to attribute motives to the judges so easily. But now, in the changing face of the society with social media, everything you do, people will attach motives to you. And that's the reason why I say avoid entry of the lawyers in your chamber, because one doesn't know what will happen. A lawyer will come to you in your chamber, he will just extend pleasantries, or maybe some festival is there, he'll wish you, he'll go back. His client will be standing outside the chamber. We don't know what he will tell the client. There are instances I have seen this. These are, harsh realities where lawyers doing this come out of the chamber and tell the client, Miss Ivanshi Bolun Aloy. You know, it conveys different meaning. So these are the few tips which I want to give you. And please remember one thing. I talked about introspection. The reason is, that, there are lawyers and lawyers. If there is a bar function, bar gathering, normally judges attend. There will be lawyers who will come to you and they will tell you that, sir or madam, I have not seen a judge like you. You are one of the best judges I have seen. Lawyers are bound to say that. Don't take it seriously. Because that is the way lawyers behave. And therefore, it is very important to have introspection. I always tell the young judges that you please, after 2 days or 3 days, you just apply your mind, try to analyze how you have functioned in the court, what judgments you are delivered, whether you are right, whether you are wrong. So introspection is necessary. See, no lawyer is going to correct you. No lawyer is going to tell you that, sir, your behavior or madam, your behavior is not proper. You have to analyze yourself and find out whether you are performing well. First, you don't give opportunity to any lawyer to say this to you that you are the best judge. And even if he says, please develop art of ignoring it. When we are judges, we have to develop this art of, it is always said that you must have mindset. You must cultivate your mind that you understand difference between irrelevant and relevant. In the same way, in lighter vein, I am telling you that we have to, ignore several things as a judges. Several things which are irrelevant, several things you should not allow yourself to be affected. And here again, I come back to the same point. You must know the caliber of the lawyers. You must study the lawyers. Then before I turn to the other topic, I must also tell you that for the sake of transparency, now try to deliver small orders, small judgments in the open court. Slowly you practice that. Of course, there are suits and criminal matters. Suppose in some criminal case, there are 20 witnesses, there are bulky documents. It is always necessary that after conclusion of the arguments, you have to go through the entire documents. It's not easy to pull out document to read. There are bulky records. So there you can resolve the judgment delivery in chamber. But small matters, applications for appointment of commissioner, or in criminal matters, small applications, application for interim maintenance, small applications for amendment of pleadings. Slowly you must develop practice of deciding the matters in open court. Maybe there is one more thing you can do. If you hear application for temporary injunction, you can keep the matter next day for orders. You go through the papers at your residence and dictate the order in open court. See, dictating the orders in open court gives a lot of transparency. Since I am on this topic, before I go to the judgments, I must tell you one more thing. Never keep the bail applications pending for a long time, especially after you hear the arguments. If you hear the bail application, I'm talking about those who are going to work in the sessions court. Of course, there are many of the civil judges. You will be there in sessions court after a few years. The bail applications, even if you reserve your order, has to be decided at the earliest. The reason is there are so many things which are said in the corridors, especially in bail applications. In many places now, the practice on the criminal side has become commercial. It has become result-oriented practice. So category of lawyers who appear before you. To avoid any speculation, as far as those who are going to hear bail applications, they should be deciding the matter at the earliest. I'm not saying every bail application you must dictate the order on open court. I'm not saying that there may be some contentious issue you would like to apply your mind. And to the district judges, I want to tell one more thing. What I'm telling you about bail applications is more relevant in anticipatory bail applications. You must develop your mind, you must develop your mindset in such a manner that most of the anticipatory bail applications you should be able to decide in the open court. That gives a lot of transparency, that avoids speculations. This, of course, generally I am telling you, there can be cases where there are lengthy arguments, too many judgments are cited. Of course, I don't expect you to decide then and there in the court. The other issue is dealing with cantankerous lawyers who are very aggressive. First and foremost thing you have to remember is that you should never lose your balance and patience in the court. You must develop an art without really getting angry. In some cases, you must show that you have become angry. If you lose your patience and get angry with some litigant and lawyer, that will spoil your whole day. I remember, I'll not name that judge. He had given me a piece of advice after I became a judge. Because somehow he felt in those days that I'll be very soft with the lawyers and litigants. Fortunately for me, I never carried that reputation as a judge, that I was very soft. But what he told me was very important. He said that it is always necessary to give signals that you are very strong judge and you don't tolerate nonsense. Therefore, maybe once in a while, once in a week, once in a fortnight, you take some lawyer or litigant left, right, center, but without getting angry. You decide, you make up your mind, now this is a fit case where I should give signals. Because if you get really angry, it affects you in discharge of your duties. So it's all giving signals, it's all about giving signals. About the cantankerous lawyers, many judges ask me questions. Of course, today also in maybe question and answer session, I may get some questions. It is again a matter of developing an art to deal with such people, but never get bogged down. You will find some lawyers telling you that if you don't pass order the way I want it, I'll complain to the High Court. Your response should be very sober and dignified and be very firm. You should tell us, sir, ultimately I have to pass an order as per law, as per the facts of the case. So please don't say this, that if I don't decide in your favor, you will file a complaint in the High Court. Be firm. Be firm, be polite. I always give example of our great father of Justice Ramesh Dhanuka, Justice D.R. Dhanuka. I appeared before him in several matters as a junior lawyer. He used to always tell the lawyers that, look, the court is strict, but court is not harsh. Of course, the borderline is very thin, firmness and harshness, but that is what is required. You must be firm. If you are firm, if you are depth in, if you have the depth, required depth in dealing with the human beings, you will be able to handle such situations. So never ever get afraid. Never about some lawyers creating scene in your court, some lawyers browbeating you, some lawyers criticizing you in open court. Don't get affected by these things. There are 2 or 3, 4% lawyers who do this in the court. Litigants, of course, sometimes the litigants are also psychologically affected. The way our judicial system works, they get psychologically affected because, you know, in our system there are so many appeals, revisions, writ petitions. The litigation has a long life, so we must put ourselves in frame of mindset of the litigants. And last thing which I want to tell you, I have seen, maybe it may have happened to me also in the early stages of my judgeship. If a litigant is represented by a very aggressive or cantankerous lawyer, sometimes you tend to decide against that lawyer, though his client has a good case. It is not necessary that a cantankerous lawyer will not represent a client having a good cause or just cause. So therefore, please, from the beginning, develop a practice of looking through the lawyer, look at the client, look at the plight of the client, find out, forget about that lawyer. He may not be properly representing client. Find out whether the man who is represented by that man or woman who is represented by that lawyer needs justice. He needs your assistance. Other day, I was addressing judicial officers of Karnataka Judicial Academy just this Saturday. One judge to whom I had administered oath as a judge, as a civil judge, asked me a very important question, which of course I addressed the civil judges on this, that how to deal with a situation where a very senior and eminent lawyer is appearing before you against a junior lawyer. This is again a part of the principle. Justice should not only be done, but it should be seen to be done. Of course, in our legal system, whether you are a lawyer, whether you are a judge, seniority has to be respected. As a civil judge, you have to respect your colleagues who are senior civil judges, who are district judges, because our hierarchy believes in, our system believes in seniority. As a lawyer also, you must have seen, when you are sitting in a bar room, if some senior comes, you always offer a chair to him. So seniority, you have to respect the senior lawyers, but never get overawed by the senior lawyers. It's a very delicate balancing act you have to involve. I'll give you an example. Many cases we also see a junior lawyer is appearing against senior lawyer, taking advantage of his seniority. When junior lawyer is cross-examining the witness examined by the senior lawyer, the senior will try to interrupt, try to raise several objections that this question is not relevant, etc., etc., and you will try to break the link of the junior lawyer. A junior lawyer is arguing before you, senior will get up and start interrupting. These are the cases where you have to be very firm and polite with the senior lawyer. You have to tell the senior lawyer, sir, he's a junior lawyer. If he is asking irrelevant questions, I will certainly protect you. I will not allow him to ask those questions. But in such cases, if you don't protect the junior lawyers, a wrong impression will go that you are getting bogged down because of senior. When a very senior member of the bar is pitted against a junior member of the bar, the junior member of the bar requires some protection from the judge. Protection in terms of conducting the case, not protection in terms of ultimate decision. Ultimate decision may go against the junior also. If he has no case, you have to decide against him. So this is the last thing about the conduct of the court proceedings. And usual thing which I say, please ensure that you strictly follow the dais discipline. If your court starts at 11 o'clock, you have to be there at 11 o'clock. After recess, if your lunch recess ends at 3 o'clock, you have to be there on the dais at 3 o'clock. If your work is over, you may retire early and go to chamber. But dais discipline has to be maintained. You have to be there in the court at appointed hour. Now coming to the art of writing judgment, of course, it's a very long topic which will require 3 to 4 hours. Writing a judgment is of course an art. If you want to write a judgment, of course, the precondition is that you must effectively hear the matter. You must understand the case. You must be very thorough with the case law. I must tell you one thing, that please remember that when you write a judgment, you are not writing a piece of literature. Your emphasis should be on use of a very simple language. If you are writing judgment in Marathi, use very simple language. You are going to deal with the litigation at the grassroots level, where mostly, very rarely that you decide some complicated question of law. You are mostly dealing with factual aspects. And therefore, your judgment should be in simple language so that a common man, the litigant, understands why you have decided either in his favor or against him. Please read the judgments of Lord Denning, one of the greatest judges the world has seen. He uses very same plain and simple English. And most importantly, he writes very short sentences. He doesn't write a sentence running into two lines or 3 lines. Very short sentences he uses. You have to develop your own language. I always tell the judicial officers, if you want to write simple English, one of course glaring example you should follow is of just Lord Denning. The other example is writings of Mahatma Gandhi in the newspapers or weeklies, Harijan and other newspapers they used to write. See his English. You will find that no sentence has more than 6 to 7 words. He used to use very simple and correct English language. I am telling you, writing in a very simple language is a difficult task. Very difficult task. So you must use proper language which can be understood by everybody. Now, how to deal with, one question is asked to me, how to deal with large number of judgments which are cited before you. I remember in 2008, I was hearing appeal from order. That appeal from order was directed against a simple order of injunction. Order on application for temporary injunction passed by, I think, a civil judge senior division at Pune. A normal suit for specific performance where plaintiff filed an application that defendant should be restrained from creating third-party interest or parting with possession of the suit property till disposal of the suit for a specific performance. I found that advocate for plaintiff had cited 32 judgments and advocate for defendant had cited 33 judgments. So I had a very distinguished and senior lawyers appeared before me. I told them that for deciding a simple application for temporary injunction, if you throw total 65 judgments at the judge, what poor judge will do? So I told them that irrespective of the result, I am going to impose cost on both of them. So while deciding the appeal, finally I imposed cost on both of them. Now, to deal with such a situation where 10, 15, 20 judgments are given to you, firstly, if you are very well conversant with the latest case law, you will not find it difficult. You can go through those judgments. If you find that the issue is decided by a direct judgment of the Supreme Court or your own parent High Court, you can, just a suggestion, you can say that this is the law laid down which binds you, and therefore the judgment so and so versus so and so, so and so versus so and so, they may not be relevant because ultimately I am bound by the law laid down by the Supreme Court in a particular judgment. But it is very important that maybe in one sentence, 2 sentences, 3 sentences, you deal with each and every judgment relied upon before you. That is very important. There is something which you should avoid. I have seen it happening not only in Maharashtra, I have seen it in Karnataka also. While going through the judgments for writing confidential reports, some judges quote the head notes in the law reports. Please avoid this. This happens because of 2 things. One is that you don't read the entire judgment and you go by the head note. It is my experience, it will be shared by my distinguished colleagues from Bombay High Court, that there are cases after cases where you find that the head notes are most misleading. Therefore, don't go by head notes. If you want to quote ratio of a judgment, please quote the relevant paragraph or paragraphs from the judgment. Don't go by head notes. And for that, you must know what is the ratio. And for knowing what is the ratio, you must go through the entire judgment. But as I said, every day you keep on reading judgments. I am told this Supreme Court online updates itself every day in the night. So today, if I pronounce a judgment in Supreme Court and it is uploaded today itself, it will be there tomorrow on the Supreme Court online. Same is the case with the High Courts. So if you are very up to date with case law, you'll not find it difficult to deal with this flood of citations which are placed before you. So again, this makes it important to be very thorough with the case law. It's not always necessary to quote paragraphs from each judgment. You can simply say that this is what is held by the judgment. Either you can say that that is not correct because there is a judgment of the higher court or Supreme Court or the judgment of larger bench, or you can say that this ratio will not apply to the facts of the case. You can give just brief reasons. It's not necessary that you must quote the relevant paragraphs of each and every judgment, because unnecessarily judgment becomes very lengthy. Now, there is one more. I'm just now dealing with final judgments in a case. There's one more area, especially in civil matters, where you need to be careful. Please ensure that gist of submissions made by the advocates is part of your judgment. It's not necessary to, suppose some advocate gives you written arguments. It's not necessary to quote the entire thing. If there are 5 points argued by the lawyer, you say 1, 2, 3, 4, 5, 6, these are the submissions made. That is very important, because otherwise in the higher court, always an argument is made that I am made submissions on this point, but the judge has not recorded. See, as judges sitting in the high court or Supreme Court, we always tell the lawyers that look at the judgment in paragraph number so and so. The learned judge was at pains to write down all the submissions recorded made by the advocate. Why he would forget only one? Why he would ignore only one argument? But in many judgments, I find that it is not mentioned what are the submissions made. It is simply said that advocate for plaintiff has prayed for passing a decree. Defendant, advocate, yes, said that suit should be dismissed. So therefore, have that practice. There is one more advantage of this practice. If you write in your judgment, these are the points argued, that ensures that in the reasons part you deal with each and every argument. If you don't incorporate that those submissions in your judgment, perhaps you may forget some point. You will not deal with some point. That is also very important. The one issue is of the legal written arguments. Now, written arguments has become a major problem, especially in cosmopolitan cities, not in all districts, not in all taluka places. The lawyers tend to argue, lawyers tend to submit very, very verbose and very long written arguments. Normally, they will seek your permission to file written arguments. So you can record in the proceedings that advocates normally never allow written arguments to be filed before the oral arguments are heard. You can always say in your order that please give brief summary of the submissions which are made in the court. Try to develop that practice, try to inculcate that habit in the lawyers. That brief summary of the submissions, it should not be written arguments in that sense. Sometimes lawyers will tempt you by saying that, sir or madam, we don't want to make oral submissions, we'll file written submissions, you decide. As far as possible, avoid that practice. There should be oral arguments. It is only if there are oral arguments that registers on our mind as judges. And then if you start this practice, lawyer is saying that I don't want to make oral submissions. If I written submissions, lawyer will end up in filing very, very lengthy written submissions, which will find it very, very difficult to deal in your judgment. Your judgment will become very lengthy. One more thing which I want to tell when I am on the judgments. In many cases, sitting in the High Court, I have come across an argument that the judge has relied upon a decision of the higher court which was not cited before him. The reason is obvious. The judge makes his own study. He finds out that it's not, you will find in several cases that the lawyers sometimes don't cite relevant judgments. Lawyers don't cite judgments which are directly on the point. So you make your own study and use a judgment. To be fair to lawyers, you can always do this if you have heard a matter and adjourn the case for or reserve the judgment. If you want to rely upon some judgments which you on your own you have invented, you can keep the matter for further arguments and tell the lawyers that look, this is the judgment which may be against you. Please argue on this. To be very fair to the lawyer, you can do that so that that grievance is not made before the higher court. Now, interim orders. Before I go to interim orders, I want to say something about the judgments in the criminal matters. In many cases, I find that the judges simply quote what the witness has stated, what is elicited from in the cross-examination, and then state away the conclusion. This is not a good practice because when we say that you have to appreciate the evidence, suppose there are eyewitnesses in a case. If you want to believe the version of that eyewitness, you must give reasons why you are believing that witness. See, ultimately witnesses are human beings, so there are bound to be some contradiction here and there in the cross-examination. So you have to give some reasons why you are believing this witness or why you are discarding the testimony of this witness. Simply quoting what the witness has said and you say that no, these three eyewitnesses are deposed and I'm accepting their evidence. That's not sufficient. You must analyze their evidence and you must record that why you are accepting the evidence, why you are not accepting the evidence. That's very important. Because this is routinely happening. Therefore, I'm just telling you about it. And in criminal matters, there is one more aspect. When you are convicting a person and when you hear the accused on the sentence, and especially in those cases where there is no minimum sentence, please record at least some reasons. If particular offense has provision, sentence rigorous imprisonment up to 3 years, then why you are imposing only 1 year or why you are imposing only, maximum 3 years? Some reasons have to be recorded. Of course, now the law on sentencing policy is very clear. In which cases maximum punishment is to be given, in which cases the court can show leniency. That is very important. In criminal cases, one more aspect which is very important in the point of view of the judges who are going to decide appeals or revisions against your decision. It is always advisable to mention somewhere in the last part when you are convicting a person, how much period of incarceration the accused has undergone. That helps the appeal court, that helps the higher court for giving set off. It is always advisable to mention that. And that is also very relevant when you are convicting a person, when you impose a sentence. Suppose in the beginning of the trial, he has undergone incarceration for 1 month and you are deciding the case after 10 years. That will be also a factor. After 10 years, he has undergone 1 month in the beginning. After 10 years, you are sending him to jail. So it may be a factor to give slightly lower sentence. So that practice also you must follow. And one more thing, as I told you about the arguments, in civil matters after you reproduce the issues and in criminal matters after you reproduce the points for determination, it is always better to mention in the immediately next paragraph before you deal with submissions, how many witnesses have been examined and who are those witnesses. The prosecution examined 10 witnesses, it will say so, that 2 witnesses have been examined, those who are pancha witnesses, or those who are witnesses to memorandum under section 27, you mentioned that. Same is the case with civil case. Why this is important? If you mention in the flow of your judgments that these are the witnesses who are examined, then you don't forget to deal with evidence of those witnesses. And it gives completion to the judgment. That a judge of the appellate court, when he reads it, he knows the entire thing. Who are the witnesses examined, on what point witness is examined, it becomes very easy. So as you must mention the arguments, you must mention how many witnesses and who are those witnesses who have been examined. So these are all part of discipline, a mental discipline, which ultimately helps you in arriving at a correct conclusion. Now, few things I want to say before we can start question and answer session about the interim orders. Of course, the length of the interim order will depend upon the extent of arguments made before you, because you have to deal with the arguments which are made before you. But I feel that sometimes you must make a distinction between something which is of slightly more importance, like application for injunction, where you have to record finding on prima facie case, balance of convenience, irreparable loss. But there are smaller orders, like application order on application for appointment of court commissioner. You must inculcate habit of writing short orders while dealing with such applications. Short orders with good content. Similarly, in case of applications for amendment of pleadings, the grounds on which you can reject application are very well known. Maybe it's a mala fide amendment, it's a grossly time-barred amendment. So some orders, because I find sometimes even an application for amendment, judges writing judgments running into 20 pages, 25 pages, doesn't help the cause. That also is an art, how to write a judgment very briefly. Though I am a judge for 18.5 years, sometimes I also feel that I have not mastered that art sufficiently to write precise and very brief judgments. Sometimes I also tend to be lengthy, but these are the things we should develop right from the beginning of your career. Now, actually, how to write judgments in different cases. I mean, someday I would like to address you, because you know the approach is different. In criminal matters, approach is different. In civil matters, approach is different. How to write judgments in rent tax cases, how to write judgment in suits for specific performance, suit for partition. Again, a different skill is required when you deal with matrimonial disputes, how to write judgment in matrimonial disputes. So these are very, very details on which someday I would like to go. So these are the just broad features and introduction about the topic. Maybe in second time when you come back, if your director Justice Dhanuka permits me, I'll address you in much detail on these topics. So Mr. Agarwal, we can have a question and answer session.
Yes,
and usual preface which I make to question and answer session. Please ask all your doubts which are in your mind. Even when I was sitting judge of the Bombay High Court, I used to very often come to the Judicial Academy. I used to always assure the young officers that whatever questions are asked, whatever views are expressed, those views will not be communicated to any of the registrars of the High Court. So you have that assurance from me. I don't meet anybody from Bombay High Court. So those questions will remain with me only.
Sir.
And surely my colleagues who are sitting there, those questions will remain with them. So be very frank and free.
Yes, my lord.
So we can start with the questions.
Honorable Dhanuka Saheb, I think wants to add something.
Yes.
Yes, my lord.
No. We know that more and more lectures will be required, not only for our judicial officers, but for all of us. We are also going to be benefited how to write judgments, though most of us, I have at least completed more than 10 years now in judiciary. But I am benefited already by what you have spoken today.
Yes.
Please fix an early date for next session.
Mr. Brother Dhanuka, sometimes I am also benefited by judgments rendered by all of you. I mean, said, we are judges. So we are benefited from views expressed by all. Sometimes, in fact, good that you pointed out this. Sometimes I have seen manner in which some of our judicial officers write judgments. They are simply fabulous. The way they marshal the facts, the way they appreciate the evidence, some of the judgments I have seen in criminal cases. I mean, so we learn from everybody actually. That's it.
Yes.
This
Yes.
is the best to get your doubts cleared from His Lordship.
Yes.
Be frank.
Yes. So the trainee judges are requested to raise their hands so that one by one they can put their queries. So those who have questions, please raise your hand so that you can start the question answer session. Yes, Mr. Pawar, please start your mic. Mr. Pawar is a newly recruited district judge. Yes, Mr. Pawar.
Good evening, my lord.
Yes. Yes, please.
Yes, sir. Whether trial judges should maintain the submissions of advocates before points in few paragraphs, or should those submissions be mentioned as we appreciate or marshal the evidence in respect to points or in the context of the evidence we are discussing?
See, I have seen judgments written by some of the very eminent High Court judges. They have followed that you first reproduce a submission, deal with that submission, record finding. But I personally feel that, as a trial judge, you will be delivering judgment. No doubt when you deal with the arguments, when you record findings, you will be again reproducing the same submission that so and so has argued and this is your answer to that. But as a matter of discipline, it's better to record the submissions in brief before you reproduce the issues or points for determination. It's better because ultimately, whether we like it or not, we have a hierarchical system where your judgment will be tested by higher court. It's always better. Some tips I always used to give to the judge since you have said this. We must also know, I'm just telling in a very lighter vein, don't take it seriously. We must also know how the judgments will be read by the higher court. I used to always give an example. When you pass an order on interim application for grant of interim maintenance under 125, you can begin your first paragraph by saying that here is a case of a husband who is holding such and such post and he is getting salary of 1 lakh. First paragraph you mention this. So the judge of the higher court starts with that, So that is automatic justification for you, what you say, the amount of maintenance you fix. Or when you are, especially for district judge, you are a district judge, when you write a judgment, say a revision against section 125 order, you can always begin by saying that in this case, the learned magistrate found that the husband is earning 25,000 rupees and he has granted maintenance of rupees 5,000 per month. So in first paragraph, you sum up, See, ultimately all judges are human beings. So as a discipline, it's better to reproduce the submissions first. Then again, you can again deal with that separately.
Yes. Thank you, Lordship. Yes. Yes, any other query? Please raise your hand.
And language is no barrier. You can ask in Marathi also.
Yes, my lord. Yes, Mr. Munde, please start your mic. Mr. Munde, Civil Judge Junior Division. Yes, please start your mic.
Good evening, Your Lordship. My question is about, Your Lordship, how to avoid repetition at the time of assessment of marshalling, because while marshalling the evidence, we have already reproduced the testimony of the witnesses, and while assessment, it appears that it is likely to be a repetition.
Yes, you are right there. You are absolutely right that, but it is only with the experience you can deal with that. In the sense that when you are marshalling I'll give you an example of a criminal case. You are marshalling evidence of an eyewitness. Maybe you may tend to do that. Again, reproduce the same thing because you want to say that why you are not accepting or why you are discarding his evidence. But with the practice, you learn that how to really make it in concise form. It's all matter of practice. Initially, you are bound to do that. There's no problem. I mean, don't feel that you are committing some mistake. It's bound to happen.
Yes. Yes, Mr. Lunia, you raised your hand. Please start your mic. Mr. Lunia.
Yes, sir.
Mr. Lunia, please ask your question.
Good evening, Lordship. My question is regarding the appreciation of evidence, sir. Sir, appreciation करताना मार्शलिंग आपल्याला थोडं येतो की ऑर्गनाइज करायचे फॅक्ट्स, पण ऍप्रिशिएशन करताना तेवढंच जमत नाही. तर ते त्याच्यासाठी आपल्याला परफेक्शन येण्यासाठी काय करावं सर? थोडं गाईड कराल का?
नाही, आता शेवटी तुमचं मला एक तुम्ही सांगा, मी पुन्हा तुम्हालाच प्रश्न विचारतो की ऍप्रिसिएशन म्हणजे काय तुमच्या दृष्टीने? म्हणजे मार्शलिंग आणि ह्या शेवटी गोष्ट म्हणजे ऍप्रिसिएशन म्हणजे काय? तुमचा कन्सेप्ट काय ऍप्रिसिएशनचा?
सर, एखादा फॅक्ट आहे, एखादा पॉइंट आहे, से फॉर एक्झाम्पल एखादं सिव्हिल केसमध्ये टीआयचं ऍप्लिकेशन करताना प्रायम फेसी केस बघतो आपण. तर टीआयचं ऍप्लिकेशन मध्ये प्रायम फेसी केस बद्दल म्हणजे प्रायम फेसी केस इन द सेन्स सूट मध्ये जेव्हा परपेच्युअल इंजेक्शन असेल तेव्हा आपल्याला आपण बघतो की तिथं ते केस मेड आउट केली का. जेव्हा पॉइंट्स इश्यू फ्रेम करतो तेव्हा पहिल्या इश्यू बद्दल प्रत्येक विटनेस काय बोललेत आणि त्याच्याबद्दलचे डॉक्युमेंटरी एव्हिडन्स हे एकत्र करतो त्या पॉइंट बद्दलचे, त्याला मार्शलिंग म्हणतो आपण, असं माझं कन्सेप्शन आहे सर. आणि दुसरं म्हणजे ऍप्रिशिएशन करताना त्याच्याबद्दल आपलं ओपिनियन काय लॉ म्हणतोय आणि त्याच्याबद्दल
मार्शलिंग ऑफ फॅक्ट्स म्हणजे कसं आहे माहितीये का, की मी तुम्हाला थोडक्यात सांगतो. ए जज इज एक्सपेक्टेड टू बी व्हेरी थरो विथ द फॅक्ट्स. त्या फॅक्ट्स तुम्ही फॅक्ट फाइंडिंग करताना कशा वापरायच्या त्याला मार्शलिंग ऑफ फॅक्ट्स म्हणतात. ते मार्शलिंग ऑफ फॅक्ट्स म्हणजे अक्युम्युलेशन ऑफ फॅक्ट्स असं नाही. त्यामुळे मार्शलिंग ऑफ फॅक्ट्स आणि ऍप्रिसिएशन याचं फार जवळचं नातं आहे. आता मी तुम्हाला उदाहरण देतो की शेवटी मार्शलिंग म्हणतो आपण. आता आपण एखाद्या 323 किंवा 324 ची केस आहे, क्रिमिनल केस. 4 आय विटनेसेस आहेत. आता प्रत्येक आय विटनेसचा एव्हिडन्स जर इनकन्सिस्टंट असेल तरी तुम्हाला मार्शलिंग ऑफ फॅक्ट्स लागतं. किंवा जेव्हा तुम्ही PW3चा एव्हिडन्स तुम्ही जेव्हा अनालाइज करता त्या PW1 आणि PW2 जर आय विटनेसेस असतील तर त्या फॅक्ट्स तुमच्या डोक्यात पक्क्या बसलेल्या पाहिजे की ते विटनेसेस काय म्हणाले. आणि मग तुम्हाला आता ऍप्रिशिएटिंग म्हणजे काय की समजा 4 असं नाहीये की 4 आय विटनेसेस आहेत ते त्यांच्या एव्हिडन्स मध्ये कॉन्ट्राडिक्शन आहे म्हणून तुम्ही 4ही रिजेक्ट करायचं असं नसतं. ते बऱ्याच वेळेला काही वेळेला असंही होऊ शकतं की त्याच्यातली 2 आय विटनेसेसचा टेस्टिमनी तुम्ही पार्शियली ऍक्सेप्ट करू शकता, 2 आय विटनेसेस तुम्ही डिस्कार्ड करू शकता. किंवा आता पार्शियली ऍक्सेप्ट तुम्ही एखादा विटनेस ज्या काय फॅक्ट सांगतो त्या पार्शियली ऍक्सेप्ट करू शकता. यू कॅन से दॅट दिस विटनेस हॅज प्रूव्ड द इन्सिडेंट टू द पार्ट. आता हे ऍप्रिसिएशन आहे. ऍप्रिसिएशन साठी तुम्हाला मार्शलिंग ऑफ फॅक्ट्स लागतच. ऍप्रिसिएशन म्हणजे काय की ऍप्रिसिएशन इज समथिंग विच रिअली लीड्स यू टू कन्क्लुजन. Any other questions?
Yes.
You can ask as many questions you like. No problem.
There are no. Yes, there is one more. Shinde madam. Yes, madam Shinde, please ask your question.
गुड इव्हनिंग सर. सर एखाद्या
Yes.
लॉयरने जर बंच ऑफ सायटेशन्स दाखल केले असतील तर ते सगळे आपल्या ऑर्डर किंवा जजमेंट मध्ये येणं गरजेचं आहे का, किंवा मग ते कोणत्या प्रकारे कशा प्रकारे आपल्याला करता येईल त्याच्यामध्ये?
मी मगाशी तुम्हाला सांगितलं, मी पुन्हा आता एलॅबोरेट करतो ते. आता बऱ्याच वेळा काय असतं की ही जजमेंट समजा 15 जजमेंट साईट केले असतील एखाद्या वकिलांनी, तर एकाच पॉइंट वरती मल्टिप्युलर जजमेंट असू शकतात एकाच पॉइंट वरती. तर तेव्हा तुम्हाला जर लेटेस्ट लॉ माहिती असेल त्या विषयावरचा, फॉर एक्झाम्पल आता 65B आहे आपलं, नेहमीचा प्रश्न येतो इलेक्ट्रॉनिक एव्हिडन्सचा. तो वकील ऍडमिसिबिलिटीवरती 10 जजमेंट्स देईल एखादा वकील, पण तुम्हाला लेटेस्ट जजमेंट जर सुप्रीम कोर्टाला माहिती असेल तर तुम्ही त्या जजमेंटचा उल्लेख करा की ही जजमेंट्स इथे आपण केलेली आहेत, ह्या पॉईंटवरती ती जजमेंट्स आहेत, पण ह्या पॉईंटवरती डायरेक्ट अपेक्स कोर्टाचं बाइंडिंग जजमेंट आहे आणि त्या जजमेंटचा रेशो असा आहे. म्हणजे प्रत्येक जजमेंट तुम्ही स्वतः वाचून प्रत्येक जजमेंट त्याचा उल्लेख करायला पाहिजे, पण त्याचं काय लिहिलेलं आहे त्या जजमेंटमध्ये एलॅबोरेट करायची गरज नसते दरवेळेला. ते जर बाइंडिंग जजमेंट असेल तर नक्कीच करायला पाहिजे, पण त्याच विषयावरती पेरेंट हायकोर्टाचे आणि सुप्रीम कोर्टाचे जजमेंट असतील तर तुम्ही म्हणू शकता की अल्टिमेटली दिस इज द लॉ, आणि ही जी जजमेंट्स आहेत तर ही जजमेंट्स याच पॉइंटवर आहे, पण अल्टिमेटली व्हॉट आय हॅव टू फॉलो इज बाइंडिंग प्रेसिडेंट. यू कॅन से दॅट.
Thank you, Lordship. Mr. Doble, please start your mic and ask your question.
Lordship, generally in a criminal judgment, the points for determination are framed separately for each section. Can we frame the points for 2 or more section in one point?
There are two things. Firstly, in criminal cases, the points for determination have direct nexus with the charge framed. So when you frame the points for determination, you have to keep in mind the charge frame. Now, while framing the points for determination, if you club 2 charges together, perhaps that may lead to some error in the conclusion. So, see, ultimately it is like this. Some sections are interconnected. There you can have one question frame. But sometimes, in a given case, the allegation is that in case of one victim, there is 323. In case of other victim, there is 326. In case of third victim, there is 307. You can't club all this together. The victims are in one offense, I am saying. There are multiple injured persons. So therefore, in a very rare case that you can club 2 sections together while framing the points for determination. See, ultimately, why we frame points for determination, you must understand the object. The points for determination, म्हणजे काय ultimately काय आहे ते? That guides you what you have to decide. These are the points which you have to decide. That is actually some sort of a psychological reminder to you. एवढे प्रश्न आहेत, आपल्या प्रश्नाला उत्तर द्यायचे आहेत आपल्याला. त्या प्रश्नांवर आपल्याला निकाल द्यायचा आहे. त्यामुळे ते प्रश्न सुटसुटीत आणि क्लिअर असलेले चांगले असतात नेहमी.
Thank you, Lordship. I will take last 2 questions. One from Mr. Shinde, District Judge. Mr. Shinde, please ask your question.
Lordship, I have 2 issues. आता याच्यामध्ये बऱ्याच वेळेला असं होतं की एखाद्या स्टेशनला नवीन कोर्ट आल्यानंतर जे वकील वर्ग असतात ते अंदाज घेतात की साहेबांचा पर्टिक्युलर मॅटर, म्हणजे आता सिव्हिल जर कन्सिडर केले, एक्झिबिट 5 कन्सिडर करताना ते रिलीफ देतात नाही देतात, एबी आहेत किंवा पर्टिक्युलर टाईपचे बेल आहेत, 376 आहेत किंवा पोक्सो मॅटर. तर त्यांना असं वाटलं की ह्या सगळ्यात आता एबी मध्ये काय काय कोर्ट असं करतात की रिलीफ देत नाहीत किंवा निशाणी पास मध्ये इंटरिम प्रोटेक्शन वगैरे असं बऱ्याच गोष्टी करत नाहीत. तर त्या ठिकाणी असं केलं जाते की मग त्या ठिकाणी कामच चालवायचं नाही त्यांच्या समोर. म्हणजे इनडायरेक्ट बॉयकॉट केल्यासारखं केलं जातं. तर अशा सिच्युएशन मध्ये आपण कसं डील केलं पाहिजे?
एक 2-3 गोष्टी मी याच्याबद्दल तुम्हाला सांगतो. पहिली गोष्ट म्हणजे तेव्हा तुमची जेव्हा नवीन अपॉइंटमेंट होते, तुमचं पहिलं पोस्टिंग असतं किंवा पुन्हा दुसऱ्या पोस्टवर तुम्ही ट्रान्सफर होऊन दुसऱ्या पोस्टवर गेलात, ही एक नॅचरल ह्युमन टेंडन्सी आहे. शेवटी त्या वकिलांना काय असतं की त्यांच्या पक्षकारांना त्यांना लीव्ह मिळवून द्यायचा असतो. थोडे दिवस ते जजला टेस्ट करणार, याच्यात काही विशेष नाही. दुसरी गोष्ट कशी आहे म्हणजे काही गोष्टी बाबतीत मी असं पाहिलेलं आहे, मी वकील म्हणून माझा अनुभव सांगतो की अनेक न्यायाधीशांना अशा काहीतरी एक फिक्स नोशन ठेवलेले असतात. मला आठवतं एक सिव्हिल जज त्याच्यापुढे प्रॅक्टिस करायचं, मी ते असं सांगायचंय, मी कुठल्याही केसमध्ये एक्सपार्टी इंजंक्शन देत नाही. एक जज असं सांगायचे की मी 376च्या केसमध्ये बेल देत नाही. तर ऍज जजेस तुम्हाला पण आपण असे फिक्स नोशन आपल्या मनामध्ये ठेवायचं नाही. आपल्याला पॉवर आहे एक्सपार्टी इंजंक्शन द्यायची. Wherever case is there, you have to grant injunction. Wherever case is made out for grant of bail, you have to grant bail. बऱ्याच वेळेला हे काय होतं की आपण काम करताना आपल्या काही नोशन्स फिक्स होऊन जातात. आपण असं विचार करायला लागतो की कशाला इंजंक्शन द्यायचं, एक्सपर्ट इंजंक्शन, आपल्या विरुद्ध ॲलिगेशन होतील. कशाला एखाद्या सेन्सिटिव्ह केसमध्ये बेल द्यायचा, आपल्या विरुद्ध ॲलिगेशन होतील. असा काहीतरी माइंडसेट आपला होत जातो. आणि ज्याला आपण इंग्लिशमध्ये स्टिरियोटाइप्स म्हणतात, स्टिरियोटाइप व्हायला लागतं सगळं, स्टिरियोटाइप्स डेव्हलप व्हायला लागतात. तर थोडंसं ते जजेसमुळे पण होतं की इतका आपला फिक्स माइंडसेट आपण जर दाखवला की आपण अमुक अमुक केसमध्ये रिलीफ देतच नाही, केस कशी असून दे, तर मग अशी प्रवृत्ती वकिलांची होते. पण मला असं वाटतं की एवढ्या वर्षांचा माझा अनुभव आहे की तुमचा अप्रोच चांगला असेल, तुम्ही फेअर असाल, सुरुवातीला अशा अडचणी येतील की काम करायला तयार नसतील वकील लोक, पण तुमचा अप्रोच जर चांगला असेल तर असे प्रसंग येणार नाही. थोड्या दिवसांनी वकिलांच्या लक्षात येईल की हा जज आहे, हा अभ्यासू आहे, त्याचा अप्रोच चांगला आहे, हा फेअर आहे, म्हटल्यानंतर तशी वेळ येणार नाही तुमच्यावरती, असं मला वाटतं. फक्त काही स्टिरियोटाइप्स असे होऊन देऊ नका, तुम्ही फिक्स नोशन्स ठेवू नका.
थँक्यू लॉर्डशिप. लास्ट क्वेश्चन फ्रॉम मिस्टर गुरव. Yes, Mr. Guru, please start your mic. Roll number 67. Sir, I don't think now there is no question. I think the questions are over. So we come to the.
Yes. I'll ask one question.
Yes, my lord.
It is noticed by us in so many matters that large number of judgments are cited by one or the other party, and they are distinguished in one line that they are not applicable to the facts of this case.
Right.
Refer to 15 judgments, and in one line they are knocked out, and then there is a grievance in High Court that these judgments are not cited. So how to distinguish?
So,
what
therefore I said, while answering the question, the judges will have to study those judgments, they have to find out. And in one line they can say that on this point, these 3 judgments are cited in support of this proposition. Either he can say that considering these facts, they are not relevant, or he can say that on this very proposition 3 judgments are cited, but there is a binding judgment of a larger bench or Supreme Court. This is how they have to deal with it.
Very brief reasons have to be given. You can't.
Some reasons have to be given. You're right. Absolutely right. One reason can be that on the same point there are binding judgments. Another reason, of course, will have to be on facts.
Yes. Thank you, Lordship. With your Lordship's kind permission, may I now conclude the program?
Yes, please.
Session. My Lord, I'm at loss for words actually for this invaluable guidance of your Lordships to all the trainee judges as well as all of us at the Academy on how to conduct the court proceedings and how to write judgments. Lordships, at this crucial stage of all the trainee judges, at this crucial stage of their career, I think this session will go a long way in helping them to understand the concept of conducting court proceedings and as well as writing judgments. Of course, as my Lord Justice Dhanuka said, we would love to have your Lordships here physically. As far as the judgment writing is concerned, we can have a detailed, a long session from your Lordships if physically it is possible in future, in near future. Definitely. So I'm really grateful.
Mr. Agarwal, personally, I always believe that in academies there should be physical lectures. Of course, this COVID situation we can't help it, but I personally believe that way.
Yes, yes.
Then only
Lordship,
it
but-
becomes effective.
Yes, yes, my lord, that is true. That is correct. So I'm really, I express my deep sense of gratitude to your lordship for this session, despite a very hectic schedule. And I'm also grateful for Honorable Shri Justice Dhanuka, the officiating director of MJA, for blessing us with his presence. And of course, Honorable Justice G.S. Kulkarni, Honorable Justice V.G. Bisht, and Honorable Shri Justice Madhav Jamdar for blessing us with their presence and motivating us in this session. And I also thank the technical staff of High Court for arranging this session on a holiday, because it was a holiday today for this Maharashtra.
Oh,
So
today is not a holiday. It was
sir,
holiday.
today,
Yes.
holiday was declared because of
Lata
demise.
Mangeshkar, okay. I was not aware of that. I was not aware.
Declared this.
Yesterday evening
Yes.
it was declared.
Okay, okay.
Yes, my lord. So we are looking forward to many more sessions from your lordship. And I also thank all the trainee judges for their active participation and my colleagues at MJ. So thank you, my lord. And
Thank you. All the best. All the best. Thank you.
thank you, lordship. Thank you so much. Thank you, my lords. Thank you so much.